Good afternoon, and welcome to the Smart Women 2010 webinar series. 30 minutes on the clock, 20 minutes to teach, and 10 to talk. Smart Women is a platform offered through Urban Wealth Management designed to provide our community with the tools and resources they need to create the lifestyle they desire and deserve. Our calls are held the second Thursday of each month from 1 to 1:30 p.m. Pacific Standard Time. We cover not only financial and investment topics, but lifestyle issues as well. As you can see, we've got some great topics and speakers lined up for you. In May, Martha Schumann with Pax World Investments, the first socially responsible mutual fund family, will be back with us discussing the very hot topic of investing in women and why it matters. In June, Nancy Harris, real estate and mortgage professional, will be on tap to give us the 411 on developing trends in real estate. Since we'll be right at the beginning of the high season in real estate, it should be a pretty timely topic, especially if you're considering refinancing, buying, or selling. We've got a great lineup for you to the end of the year, so to be sure to be able to visit our website for a variety of different topics, blogs, and events. Currently, for example, this is tax week, so we've got a great blog about 5 things not to worry about. Did you know that actually tax filing day is next Monday, not tomorrow? So our blog will tell you why. Today's call is being recorded and will be available for replay for all who have registered and will be sent out within a few hours after the call. So if you have any questions or comments, please use the chat box, which, depending on the device that you're on, could either be at the top of your screen or at the bottom. We're going to try as best as possible to stay on time, but for those who want to continue the conversation, feel free to reach out to us for additional information, comments, or even ideas about future webinar topics. We are very open to hearing more about that. So let's get this party started. Did you know that pet ownership in this country is at an all-time high? According to the American Pet Products Association, roughly 80 million households, or 65% of U.S. households, have a pet. And that's up from 56% and 66 million households in 2012. Furthermore, 98% of those households consider themselves to be, their pets to be family members or companions. But according to the Humane Society, it's estimated that only 27% of owners have made provisions for their pets in the event their pet outlives them or if they become incapacitated, which leaves a huge part of their lives in the balance, with some going to other family members or friends, but many going to shelters, and others unfortunately being euthanized, an outcome no one really wants to face. This can be avoided by taking steps to include your pet in your estate plan. Sona Tatiyants, co-founder of Lynk Law, is a premier estate planning firm with 2 offices in the Los Angeles County area. She focuses on estate planning and taxation issues. And while she's speaking on including pets in your estate planning, I can assure you she specializes in all matters related to 2-legged animals too. Welcome, Sona. We'll get you there.
Thanks for having me, Renee.
Great, thank you.
Absolutely. So I will take it from here.
Very good, thank you.
Okay, great. So we are going to talk about estate planning for pets. When I tell people I am an estate planning attorney, they kind of don't have an idea what that is. And I'm just going to give you a quick overview of what an estate plan is. An estate plan is a set of documents that allows you to decide who gets what and how. So it puts you in the driver's seat in how your assets will be distributed, who they will go to, and how the plan will be taken over and carried out after you're gone or in case you're incapacitated. So we're located in California, but this pretty much is the law in all other states in that pets are considered to be personal property. So I don't know about you ladies, I'm sure you would want to take care of Fido more than you care to take care of your couch, unless maybe you have a designer couch. But as you can imagine, a dog and a couch both treated as personal property. And many clients that I meet with, surprisingly, don't even have a plan for their pets. So this is what we want to talk about, give you options of what there is and what you can do to make sure that your four-legged loved ones are also taken care of. So there are really 4 ways that you can address this in an estate plan. The easiest way is called a personal memorandum, and you don't even need to see an attorney for this. So you can sit down and you write in a memorandum, if I am incapacitated, if I pass away, I want my dog, I want my cat to go to this individual. Now, if you want to do something that's more formal, you can do it in 3 estate planning documents. One's called a will, one's called a trust, and the last one we'll be talking a lot about is a standalone pet trust. So what you can do is you can have an attorney help you draft a document, and within the document you can specify who gets your pets and how much they will get for taking care of your pet. Let me actually explain to you what a trust is, because a trust is a very common way that we distribute assets after your passing in California. So think of a trust as a document that has 3 distinct roles in it. So there's the person who creates the trust. There's the person who is the trustee. That's the person who gets to manage the trust assets. And most importantly, who is going to be the beneficiary of that trust. So you could have a trust created right now. You can manage the trust assets and say when you pass away, you want a third party, a friend, your financial advisor, your CPA, your lawyer to step in and manage the assets for the benefit of, it could be adults, it could be minor children, or it could be your pets. So that's the gist of a trust. When we think about estate planning for pets, inevitably everyone thinks of Leona Helmsley because she was the person who first did this. And when she did this, actually pet trusts were not even legal. So she was the one to put this out there and say, I really care for my dog. She has a Maltese named Trouble, and she left her dog Trouble $12 million in trust. And she left nothing to her grandchildren. Now, this is a very extreme example of someone, trying to do something for a pet. Obviously, she came from with good intentions, but I don't know about you, unless this dog is eating, pounds and pounds of filet mignon a day, I don't think anyone could go through $12 million, especially a dog, for their care. But once you put this out there, other celebrities and other regular folks decided, hey, this is a really good idea. I may not have $12 million to leave to my dog, but I want to make sure that they're taken care of. So 2 other very good examples of celebrities who have taken care of their dogs are Joan Rivers and Alexander McQueen. For example, Joan Rivers specifically designated who will be the caregiver for her 4 dogs, and she left specific funds and directions on how they should be taken care of. Alexander McQueen did something similar, but even beyond that, he created a standalone pet trust that said after his pets have passed away, whatever funds remain in that trust, he would like it to be designated to specific animal charities. So those are 2 very good examples of when a pet trust could be done to protect your pets and also leave charitable, the remainder to go to charitable organizations. So let me talk to you about 2 common ways that we plan for pets in trusts. One would be having specific provisions in what's called a revocable living trust. So a revocable living trust would be created by an individual, and that revocable living trust would say, if I pass away, my house goes to my spouse, it goes to my children, and then my dog will go to a specific individual, and this is how that person will get funds for them. So it's a trust created specifically for distribution of your assets, and it would have a specific provision for your dog. And then we have what's called a stand-alone pet trust that's created specifically to be there for your pet. So let's talk about the revocable trust provisions. An example of this would say, when I pass away, I give my dog to my sister along with $5,000 to care for the dog. So what that means is after your passing, your trust will be administered, your sister will get your dog, she will get $5,000, and the trust will cease to exist. The thing is, if your sister decides to use the $5,000 for something else, or she needs more funds for your dog, she would not have the ability to get additional funds. So in essence, this is an easy way to make sure that your pets are taken care of, but it may not be the most accurate way of doing it because you're kind of guessing as to what your dog would need. The other option, the standalone pet trust, is a trust that comes into existence after you have passed away, and it says, I want, for example, to give $100,000 in trust to take care of my horse. My sister will be the caregiver. My best friend will invest the funds and give my sister the funds to take care of my horse as long as the horse is alive. If there are any funds left over after the passing of my horse, you can decide who gets those funds. It could go to a particular individual. Let's say your caregiver, your sister could be rewarded for taking care of your horse. Or it could go to an animal charity or some other organization. And at this point, 47 states, including California, have allowed for such pet trusts. And this is really in the last 6 to 7 years this law came into effect. And now pets, as even though they're considered to be personal property, could be beneficiaries of a trust. So the type of pets that people consider doing this for would be pets that would need significant financial support, like horses. Parrots live for a very long time. Tortoises live for a very long time. So those are the type of pets where I've seen this done before. Another interesting thing to consider is how do you determine how much money to leave? And this, our firm has come up with a formula that we often include in our trust that helps people think about how much do I want to leave. Sometimes clients will say, I want to leave $5,000 for my dog. Well, where did you come up with that $5,000? I don't know. I just thought that would be a fair amount. So we'll say something like this. Let's come up with a formula based on how old your pet is and what their annual expenses are, because some pets have more expenses. Some may have, various either diseases, or they have vet costs or grooming costs that may be significantly more, or dietary restrictions than some other pets. So an example of such a clause would be, in our trust, we would say something like, at the time that I'm creating my trust, my dog Fido is 1 year old. I believe that his life expectancy would be approximately 15 years. Upon my passing, determine how old Fido is, and then multiply that by the annual expenses that I have outlined for him, and then make a distribution for that amount to the caregiver of my pet. This way, you have a more direct number that you're giving them, and then they understand the caregiver is getting a number or getting the amount of funds that is more closely related what the annual expenses are of a pet versus just coming up with a number. And the formula could also be used for future pets that you have. So let's say you only have one dog right now. At the time of your passing, you have two. We can even say this formula would be used for any future pets that I have. So this could be a way to guarantee that the funds they're getting would be sufficient. And we can even be a little bit lenient and add a little bit more to the annual expenses just to think about if anything else comes up that you may not consider in the future. So let's review the two options of trust we have discussed. Option one is the revocable trust provisions. These are cheaper and easier to take care of because there's obviously expenses associated with administering a trust. So most people that we work with in California have a revocable trust, and we'll just add a specific paragraph or provision for the pets. The payments given for a pet through a revocable trust is typically a lump sum of money. Even though we're using a formula, it still could be lump sum of money. So again, the example would be, give my sister $5,000 for the caregiving of my dog. The problem is we don't know if the person, the caregiver, decides not to use the funds for the dog. There's no way to enforce it. Once they have the pet, once they have the funds, there's no more control that the trustee can take over and say, you didn't use the money for the vet, or you didn't use the funds for the dog. So there's no real way to enforce this. You just really have to trust the person that they will care for your dog or for your cat as much as you will, and carry out your wishes. If you want to make sure that your wishes are specifically carried out, you could have what's called a standalone pet trust. And again, you would have a separate caregiver for the dog, and you would have, your pet, and you would have a separate person investing the funds that are left for the animal. So the person who's investing the funds would be the trustee. The trustee and the caregiver would speak to each other on a monthly basis, quarterly basis, to talk about what are the expenses of the animal, and the trustee would provide for those funds to be used for the sake of the animal. And the trustee could also ask for an accounting to say, this is what the funds I gave you. Make sure there are receipts that they were actually spent towards the vet or spent towards the toys. Or the trustee could even purchase the particular items that the owner wanted the dog or to the animal to have. This is obviously going to be costlier because once a person passes, to carry out and administer and invest the funds for the benefit of the animal will take as long as the animal was still alive, and it may take a longer period of time. But it absolutely guarantees that the person's wishes will be carried out as to how their pets will be taken care of. Another planning tool, if you are charitably inclined, is called a charitable remainder trust. These are type of trusts that an individual could create during their lifetime where, for example, they can put an asset, whether it's an apartment building or investment account they have, and the income of the asset could go towards a charity during their lifetime. And upon their passing, it would be distributed to certain individuals. When you create these type of charitable trusts, you get a significant tax break on the assets that you have put into this trust. So there's also tax benefits to individuals doing this. So this is just another planning tool if you're charitably inclined. What you should consider after getting off this call is if you already have an estate plan, what are some of the things that you could actually do with your existing estate plan? So definitely consider if you have a will or a trust, do you have provisions included for your pets? Whether you're giving them a lump sum of money or using a formula to give certain funds for your pet, consider if you've done this. And if there's a caregiver specifically named who will take care of your pet and who will receive the funds for their benefit. Another thing to consider is you want to make sure similar type of provisions are written into your power of attorney. Power of attorney is a document that allows someone to take care of your needs, including the needs of your pet during your incapacity. So you want to make sure funds are available and someone is designated as a temporary caregiver for your pet in case you are incapacitated. I do have one last tip for you. So if you, again, are charitably inclined and want to leave certain animal organizations or other organizations funds upon your passing, you may want to talk to someone like Renee to make sure that you are making the right, you're choosing the right assets to give to a charity. Certain type of assets that we have, like IRAs and 401ks, are tax-deferred assets. And if you were to leave your 401k that has, let's say, $100,000 in it versus $100,000 worth of cash, when you leave that 401k to a charity, they will not pay any of the deferred taxes on it. Versus if you leave it to an individual, they will end up paying taxes on it. So definitely talk to Renee or your financial advisor to decide which assets are best left to a charity and which assets are best left to your family and friends. That's all I have for now, and I think I'm on the 20-minute mark.
All right. That's great. Thanks, Sona. I mean, I think that given the statistics that I shared at the beginning of the talk, it's a huge, huge issue for, it should be for a lot of families, because virtually everyone has a pet, whether it's a cat, a dog, a bird, or a horse, or whatever. And I don't think we really do think about the fact that there are some other considerations. So if there are any questions, I know a couple came in that I wanted to ask about, but certainly any of you that are on the call, to please type in your questions in the chat box. So Sona, can you speak to, do you have to find an attorney who specializes in this, or can any estate planning attorney do it?
Well, most estate planning attorneys are familiar with pet trusts at this point. I know some are more inclined to do it than others. It's part of our intake process. Our questionnaire asks, do you have pets? And people will tell me, oh, you know what, I didn't even think about it, but yes, I do, and this person should take care of them. So if your attorney does not ask you, definitely bring this up with them. But it's something that happens so often, and it's something that we plan with very often in my firm. So I would imagine other attorneys would ask this as well.
Okay, hopefully so. So what happens also if you happen to move to a state that doesn't recognize a pet as personal property?
That's the problem. If they all recognize pets as personal property, but some states do not allow you to have these certain standalone provisions for a pet. So if it would be considered a gift that could not be carried out, and probably the courts will step in and try to change a distribution. Either instead of having the trust go on for the benefit of the pet, they would just make an outright distribution to the caregiver, whoever the caregiver is. Again, the problem is once the caregiver gets the money, there's no one there to supervise and make sure that the funds are properly used for the benefit of the pet.
Yeah, I can imagine. I mean, if you have a situation like Leona Helmsley, who leaves a substantial amount of money to a four-legged animal, I mean, I would think that there would be major, contests. People would be contesting that estate.
Absolutely.
And I don't even recall what actually happened with that. Do you remember?
So she. At the time that she left the funds for her dog, New York did not recognize pet trusts, but there was sufficient evidence to show how fond she was of this Maltese. So they eventually, what they did was they allowed, I think, $2 million for the benefit of her dog Trouble, and the grandchildren did end up getting something through the contest. What's unfortunate is that her wishes were very clear that she wanted the dog to get everything or most of her estate, but nothing's preventing other beneficiaries or heirs who are disgruntled to come forward and bring a lawsuit. And just to avoid the lawsuit, the estate ended up settling, and then they just gave a smaller percentage towards the dog, and the grandchildren got something.
Wow. But I'm sure that took quite some time, and probably
it did. Absolutely did.
Yeah. And who wants to do that, right? That's the whole idea of having a trust, so that you don't have to.
Absolutely. And that's the thing is most people, they have ideas of how things will be distributed, but really the law dictates who gets what. So if you want things to go to your pets, you want things to go to charitable organizations instead of your heirs at law, who are typically parents, spouses, and children. If you want to leave money to someone other than those individuals, or you don't have a spouse or a child, you want to specifically carry out and write out where you want your funds to go. Because if you don't, the probate code will have specifically ideas of how it will be distributed. And most people that I talk to, they don't like how that distribution will be. So, they'll say, well, I'm very close with my friend instead of my distant cousin. I don't want my distant cousin, who's considered my heir, to get anything. So that becomes very difficult if you don't have an idea of what the law says. So you want to specifically have your wishes carried out. Make sure it's in writing.
Okay. And one final point I would want to make, because I did a little research before we had our call today. It seems to me that demographically we have a lot more elderly people who own pets because they are real true companions. Are you finding that in your practice, and that or making elderly people or maybe some of your clients' parents aware of the fact that if these pets are their companions, that they really do need to have some kind of plan in place for what happens to them if they become ill, incapacitated, or pass away?
Absolutely. I have quite a few clients who are retired or post-retirement age who have pets, and actually many of them will want to make sure they have an estate plan before they get a new pet. I had a client whose husband passed, and they have an elderly dog, and she says, I want to get a puppy, but before I get a puppy, I want to make sure that this puppy is going to be well taken care of, because as far as I'm concerned, the puppy is going to outlive me. So we came up with a very good plan of what will happen to the older dog and the puppy if something was to happen to her. I had another client recently pass, and she had 5 cats, and she specifically had nominated a very good friend to take care of the cats, and he took them, and the transaction happened, and she also left some funds for the friend. So it had a really good ending to a sad situation. The cats ended up in a very loving home, and they also got funds to go along with them.
Excellent, excellent. Wow. Well, great, Sona. You have been amazing. For those of you who are here on the call, Sona is in, I imagine, practices in other areas outside of the Los Angeles area. Here's her website. It will go out with the replay, so you'll be able to contact Sona directly. She is amazing. I actually have some clients that I just found out recently that are going to her and have and are in the process or having their estate plan done, as well as other professionals have spoken very highly of her. So I really, really appreciate you being here today and sharing your expertise and your time, because I know you're a very busy lady. But we are right up at the 1:30 mark, and if any of you have any questions or feedback, we'll make sure that you get connected with Sona so that you can ask her your estate planning questions, as well as if you don't have an estate plan, to get one, or if you do have one, to have it evaluated or reevaluated in light of today's conversation.
Thank you so much for having me, Renee.
Thank you.
I had a blast. This was wonderful.
Great. Thank you. All right, everyone, take care. And we look forward to having you next month when we do have a conversation about why investing in women matters with PAX World Martha Schumann, who will be back joining us again. So have a great month, and we will see you or speak with you, or you'll hear from us next month. Bye-bye.